Welcome, everybody. It is oh my God, it's the last day of April. Happy cruelest month. April is the cruelest month. It is Wednesday, April 30th. Welcome to Senate Economic Development, Housing and General Affairs. We are beginning with a sunset of our to-go drinks, which we put into play during COVID, H339. And we are going to begin with our wonderful presenter from the House, Lucy Boyden. Welcome. And if you would frame up the ever so short bill and ever so short discussion that you've had in the House come up, would you be kind enough to tell us what this does?
Yeah, so for the record, I'm representative Lucy Boyden. I represent Cambridge and Waterville, which is Memorial 3, coming to you from the House Government Operations and Military Affairs. H339 proposes to remove the sunset on the sale of alcoholic beverages for off-premise consumption. And so in 2021, Act 70 permitted first and third class licensees to sell malt, vinous, and spirit-based prepared drinks for off-premise consumption, as well as permitted second and fourth class licenses to provide curbside pickup of unopened containers of alcoholic beverages. So we heard from the Commissioner of the Department of Liquor and Lottery that their Office of Compliance and Enforcement conducted a comprehensive assessment of the impact of alcoholic beverages for off-premise consumption on public safety through routine inspections and compliance checks, and their findings indicated that there have been no significant public safety or compliance issues or high concerns. We also heard from the Vermont Chamber of Commerce, Legislative Council, and the bill passed out of committee on a 10-0-1 vote and passed through the floor with flying colors.
I'm shocked.
Are you ready for a motion?
No, we're actually going to hear from all our witnesses.
Sure.
Some of us,
Sure.
Thank you, Lucy.
No
Any
problem.
questions, Lucy? Okay, great.
Okay.
Then I think we're going to pivot to Tucker, who's going to just chat with us about, and share with the general audience on YouTube the underlying statute and what we are sunsetting.
Well, good morning, everyone. Tucker Anderson, Legislative Counsel. You should have in front of you
The ever so brief bill.
H339 as passed the House. It looks confusing, and perhaps it is, but you're going back in time twice with this bill. So 7 VSA Section 230 was enacted with a 2-year prospective repeal, what you call colloquially sunset.
Sorry.
And prior to the sunset of that statute, the General Assembly reached back in time once and extended the sunset for another 2 years, and then has subsequently reached back again to extend it by 1 year. In that interim period, the General Assembly requested a report on the public safety and public health impacts of the sale of alcoholic beverages to go, and has subsequently received that report. And your House Committee on Government Operations passed out H339, which again reaches all the way back to 2021 Acts and Resolves number 70, Section 7, to remove the sunset. So this would make it so that 7 VSA Section 230 will exist in perpetuity, or at least until the General Assembly decides to repeal this in the future.
Which means,
may or may not happen.
right, which means to-go drinks forever. This is the to-go drinks forever bill.
Indefinitely. Perhaps not forever.
Tucker's fine distinctions.
I'm known for my fine
So-
distinctions and my distinct fineness.
I had been the one who pushed very hard for the report to know what the impact was on our roads and public safety and anything else. It has appeared that there is no significant, or actually almost no impact at all And so that has supported, this notion that we might do to-go drinks for an indefinite period of time. I thought we passed this originally in our last, second half of the session that we put off in 2020, but we didn't. It was in 21?
It was in the, trying to remember back to when, it was in 2021. So 2020, we all went home, and
Well,
then
then we came back and then
we came back.
back.
And when we came back, the governor had issued, I believe, an executive order attempting to accomplish some of these things, and it was in the following session that the issue was
That we
raised.
actually resolved it, yeah.
Yes, that the executive order could not supersede statute, and you had to actually create this to-go program.
Right. God, thank you. That helps me remember it more clearly. So I think let's hear from Wendy and Amy, and then we'll have some discussion and may make a decision. Amy, welcome. Tucker, why don't you stay right there? And just in case there are questions. Amy, welcome. It's good to have you. You know us all, I think. Lucy, thanks.
Thank you. So thank you for having me today. Appreciate the opportunity. For the record, my name is Amy Sphere. I'm the president of the Vermont Chamber of Commerce. I am also speaking as a representative of Vermont Independent Restaurants, which is a working partner of the Vermont Chamber, charged with preserving and advancing Vermont's restaurant and bar industry. So as I mentioned, we appreciate the opportunity to weigh in on this issue. Both the Vermont Chamber and VTIR support the repeal of the sunset provision currently governing the sale of alcoholic beverages for off-premises consumption. As you will hear from Commissioner Knight, and you've heard a little bit earlier today, the Department of Liquor and Lotteries assessment has not found that off-premises sales or the program did not result in public safety or compliance issues. As such, we're asking that the program's continued program's continued temporary status is no longer necessary, and the measure should be made permanent. As we heard during the pandemic, the sale of alcoholic beverages for off-premises consumption were very important as a lifeline for restaurants, providing a critical revenue stream. So not only did the program provide much needed financial support during challenging times, but adult consumers have come to expect the service. A national survey conducted in 2019 indicated that 56% of adults would order drinks with their to-go orders if available, and the pandemic has only accelerated that trend. In preparation for today, I connected with several of our members to get their perspectives. And while generally it is not a major source of revenue stream in their to-go line of business, it is a very important one. They all echoed that sentiment. For many restaurants, the struggle with increased cost of goods and labors really does continue unabated. And in this context, offering off-premises alcohol sales is more than a convenience. It again continues to be an important tool that provides long-term operational stability. On page 2 of my testimony that I believe you have in front of me, I did share a map of the status of to-go alcohol programs across the country. That graphic is as of July. I know it's moving in some states right now as well, but just to give you a context of where Vermont sits in this program. I will end there to keep my remarks brief. I know that the committee has a lot on their plate today, but thank you for your time and consideration on this issue.
Thanks, Amy. I know it's a small percent of sales. Do you have a notion of how many, with your independent restaurants, how many to-go meals, what percent of to-go meals have an accompanying to-go drink?
Yeah, it's generally a very small number. I asked for some financial breakdown for a couple of the restaurants. I received it from 5. I would say most of them are under that 10% mark. So again, the priority is on that food side of things. There has been more of a shift towards, there are still some restaurants that might serve a margarita, for example, to go that they've made in-house and they have all the labeling on it. But there also has been more of a movement to, I'm going to order a can of beer with my to-go order. So it's really a very small percentage that we're seeing there. So under 10%, I would say generally is the average when you're looking at total to-go.
And my guess is it has a seasonal impact, that picnickers in the summer are more likely, if they're doing something, that it would go up in the summer. Any questions for Amy? Gentlemen? Thank you, Amy.
Thank you.
Much appreciated.
Yeah.
And is Wendy gonna testify, or are we?
I just sent her an email.
There.
She should confirm.
Okay, Wendy, we look forward to seeing you somewhere. Okay, well, I think she will confirm everything that you've already heard, which is the report has continued to support the fact that this has almost no public safety or public health concerns. You've heard that it, actually the opportunity was, the uptake, I think, was much more considerable during COVID. It's now gone back to being a pretty de minimis amount of use. And our question before us is whether we want to make this a permanent opportunity for Vermonters.
Reading the report from Liquor and Lottery.
Yeah.
In terms of how they measured whether or not it had any impact. And I gather that from reading the report, and why it would be helpful to have Wendy testify.
I agree.
They look for violations associated with their inspections of
Right.
premises.
I'm just gonna text her and
But
see if she's.
that doesn't tell me, unless I'm missing something of what's in this report. Place of last drink cases, that's one of the things that she does, that this report includes. In the time frame of the examination, they do a place of last drink
Right.
is put next to, in effect, any violations. And I'm assuming that's DWIs that occur.
Right.
And it is. And they did not find any significant difference at all. Only one violation, in fact,
Right.
involved to-go alcoholic beverages, and no violations linked to curbside pickup. So it's reasonably powerful, but they haven't found any. That's one question I have about just of DUI cases generally.
Well, the
from
DUI cases
before and after
clog our courts.
pandemic. Has
Yeah.
there been any change, upward, downward, or is it more or less even?
That's a, there she
There she
is.
is.
I just texted you.
I just testified for you since you weren't here.
Perfect, thank you.
Wendy, why don't you join us? We're in the middle of a discussion of your report, actually, and you, why don't you join us?
You're quick this morning, Madam
No,
Chair.
We started at 9, and as you know, this is everybody's favorite subject, and
Yeah,
it's going
I
quickly.
was waiting out in the hallway for my turn.
Oh,
Sorry
well,
if I'm
there
late.
you are. You should boldly move in here.
Thinking of allowing curbside beverages to be served at legislative hearings as well.
Perfect. I think that's a great.
Yeah, we
idea.
are curbside, as you can hear with the
Yes,
beep, beep, beep.
Yes. Good morning.
Good morning, Wendy Knight. Welcome. It's good to have you. We are talking about
Thank you for having me.
To Go Forever.
Yes, we are. This is the second study that the department has done.
And we appreciate.
You're very welcome.
I'm the big
I
person
know
pushing
you
to
are.
study, because you know how much I
Our
love
pleasure to do the study for you,
this.
Madam Chair.
Thank you.
So it's very short, and I can just summarize it that in, for basically 3.5 years between July 2021 and November 2024, we conducted over 7,200 routine compliance checks and inspections in the
So what does that
establishments.
involve, the compliance, 7,200 compliance checks?
Yep.
What does that involve for us?
It involves going in to an establishment, a licensed establishment, and making sure that they have their license visible, asking for records if they need. And in this case, we were asking for specifically whether or not they did to-go So if it was a bar or restaurant, if they did the to-go cocktail provision that allowed the bars and the restaurants to offer alcohol beverages with food to go.
Right. So in that case, so when you talk about doing 7,200 compliance checks, they weren't all about the to-go drinks. They
No,
were
that was
your-
just one of
your
the
normal
questions they were
compliance checks.
checking,
And
sorry.
so one additional thing you had them check was
Correct.
looking at what their to-go, if they did. what their
Correct.
To-go containers.
And then if
stuff.
it were a second-class establishment, which is a retail store, we would ask about the curbside pickup. So the to-go cocktails is for the on-premise, right? The restaurants, the bars, hotels, and then the curbside, which was the retail stores. So you see that there were only 20 violations associated with to-go alcohol sales. God bless you. And those were what they deemed minor issues, so not public safety issues. They were like, they didn't use the proper labeling, or they didn't have the proper tamper resistant seal. And then you'll see that of the monetary fines that we had issued during that same period, there was one violation for a to-go alcohol sale, and there was 0 related to curbside pickup. And the one violation was for a 4th-class license, which is a manufacturer's tasting room, and it was for failure to offer food with the to-go sales, because they need to offer food. For the place of last drink, so the place of last drink is when there's a fatality or a DUI, and if there is a nexus to a licensed establishment, we do an investigation to see if there was over-serving, and there were no sales or no pulled cases associated with to-go alcohol sales. So of the pulled cases, I don't know if there was the number there. No, I don't have the number, but there were 0 related to to-go alcohol sales. And I know that was one of the concerns initially was, right, so that's proven not to be an issue. Frankly, the assessment the department has is there are no public safety issues for an extended period of time. We're talking over 3.5 years.
And you haven't had our police officers and our state police or our local police, and you haven't had an alarm raised by public safety saying.
That's correct.
This is really, we're finding this really
Yeah.
a problem.
And I think,
Containers.
Amy Spear from the chamber testified in terms of why the licensed establishments are using it or how they're using it. Our job was to really look at the public safety element, and based on the fact that we found no public safety issues, that our recommendation is to repeal the sunset.
Thank you. Any questions?
You're very
for
welcome.
Wendy?
I have one question.
Yeah.
That is regarding the data that you collect about DUIs or accidents involving alcohol. Do you include in the numbers that you have here every fatality, regardless of whether you were aware of alcohol or an establishment being involved?
No, the pulled cases is, so what happens when there's a DUI or a fatality, the responding officer, law enforcement officer, whether it's state police or a local law enforcement agency, there's a question to ask, and they ask, if they can, I don't know the condition of the person, but the question they ask is there, where were you last, right? And so if it's indicated that person or witnesses had indicated that person was at a licensed establishment, that's when that triggers us to do a pulled investigation.
So is there, in the accident report that a state police officer or local police officer prepares, is there a place on that form for that question, or is the question something that they have to think of and ask separately?
So the question that we ask law enforcement investigators at the department, that's where we ask that question at the compliance checks. I don't believe that all the law enforcement officers around the state were asking the question did you have a to-go alcohol beverage? I don't think that that's the question they were asking. What I'm indicating is that when there was a nexus to the licensed establishment, and then that brings us involved with our law enforcement officers, that becomes a pooled investigation, a place of last drink. And that's when we ask, our investigators ask if if that involved to-go alcohol sales.
But what I'm trying to determine is how do they collect the information? In other words, let's say a state police officer stops someone they believe is driving while intoxicated, and they give them field tests and so on, and then proceed to make an arrest because they believe the person is intoxicated. What's the mechanics of them asking the question and then reporting it to you so that you can log it?
Yes, I can follow up with you on that. I'll ask our
We can ask
investigators.
Matt, or we can ask the state police.
No,
too.
we could, sure, but Skylar and Brandon would have that
Right, that
answer.
would be
I just
great.
don't have that. I know that there's a question that all law enforcement officers ask. Were you at a
Yeah,
where
what
were
was the-
you last?
Where were you
basically?
last? They're always
Correct.
trying to establish where.
Correct.
the
Where were you
person
last?
What I'm trying to understand is how that is memorialized and how it's transmitted,
Sure.
or whether that is just something that they have to think about.
No,
because there's
no, it's
form.
memorialized,
If
and I
there
can-
is, I'd just like to understand the
Yeah.
process to give me comfort that the
Absolutely.
process is actually being
Sure.
used regularly.
Yeah, and we've used this for several years, the pooled, place of last drink. So I can certainly follow up with you. I just don't happen to know the details.
Yeah, no, it's okay. It's okay. So we will await that. I would suggest that we await that before we perhaps make a decision and decide to vote on this. Unless
I always
people
vote
feel
for
different.
short bills though.
Okay, so we'll follow up with that today.
That would be great.
Okay,
And if you do it before noon, we might even be able to vote this out.
we will definitely do that. We have that. No problem.
Great. Any other questions? Terrific, yes. I mean, as the mother of a prosecutor, and given how much DUI totally hijacks both our state budget and the court time,
Yeah,
was a concern, which is
Right.
how much would this add to that?
right.
We spend hundreds of millions of dollars on DUI in
Yes.
this state,
Yep.
in all the aftermath of the impact of alcohol on our roads and in our families and in trauma in this state. So I have real concerns about this, and it appears that sadly it has, happily, it hasn't added significantly to an already,
Yes,
challenging situation.
yeah,
But it
Exactly.
doesn't appear to have impacted it negatively,
exactly. Yes.
which is where we are.
So I guess the concerns that we might have had about whether to-go alcohol sales were contributing to
Yeah.
DUs our evidence does not suggest that.
Right. Thank you.
Okay, we'll follow up.
Great, terrific.
Thank you.
Thank
Good to
you
see
very
you.
much. Any initial thoughts, people? Where are you, depending on what we find out?
I'm fine with it, assuming that the process is actually doing what's in.
I think the
Intended.
process is pretty robust, sadly. They have way too much experience with dealing with people who've had too much to drink. David, any thoughts?
No negative thoughts. It's a pretty compelling package.
Thomas?
Other states do it. I don't drink, but I do like the idea that they can drink outdoors and enjoy more of the Moscow
Yeah,
outdoor
I mean,
spaces. So.
Exactly. In the summer, this is particularly obviously during COVID, but during the summer, it's particularly good. And a nice opportunity with your picnic. Okay, we will await Wendy's further piece and then we'll take a vote on it. Sophie, would you be kind enough to join us? And we're gonna pivot to unpaid leave. And, the one crowd, I don't know if you have the coalition's email that they all sent us yesterday.
Says paid leave coalition.
Yes, good, you got it. Okay, great. Because I was gonna have them, they're the one group that haven't testified, really. And we'd be happy to have them testify if people would like. But I think let's walk through, we have the amendment that you alluded to the other day, but we have,
Yeah, just
Sophie, take it away. Sophie's a daddy.
Sophie Zadatny for the Office of Legislative Counsel. And I wanted to just double check, what amendment you wanted me to walk through. I did go ahead,
You have 3 instances of amendments last time I checked.
yes. So the most recent one was including the changes recommended by the chamber from the last time we met. That Senator Chittenden.
I don't
had
think we'd
requested.
agreed to those.
Well, that was my question, so
We
whether,
haven't agreed to those.
right, whether you
So
want to.
I'm happy to discuss them, but we haven't agreed to them.
Okay.
Wanna do that now?
Yeah, let's discuss, so let's walk through just review, or remind us, given that we do this, we don't do this in a consecutive fashion during the day. So why don't you just walk through the other 2, amendments, because we have the pilots and we have the, networks. Those are the 2 amendments that we have at the moment, and then, we're looking at the chambers. Right? Is that right?
Is that 2.1?
2.1.
I think we have it here, we have it on the 23rd. It's 2 pages. Oh, you have 6 instances of amendment. That's because all these little people, okay, got it. Is that right?
Okay.
Is it 2.1?
All right, so 2.1,
I don't have 2.1.
I think that's the one I just handed you.
That was
That's the one you
that
sent
just
me
came out
or
this
sent
morning.
over the weekend.
Okay, that's right here. Yeah. 2.1 is what, Heidi just gave us. Thank you, Heidi.
Yes, okay.
so this we had walked through before. These incorporated the changes that came from the Vermont Network, Charlie Glissaman, and from the pilots or flight crew
Right, and
members.
I think we were okay. We had pretty much signed off on both of those, is my understanding.
Right, the only change at the last one was to add in that either for themselves or for a family member. And again, that was to be consistent with the other subdivisions. So that's highlighted on the screen. That was the only change that was not.
And that
in the
was
version.
right, and this was, right, to make it consistent.
Right.
Okay. Great, so if you just discuss the 4th, 5th, and 6th that were, I believe, are those the ones proposed by the chamber?
No, well, so version 2.1 is the one that we talked about at the last meeting. The changes that the chamber recommended,
So, sorry, I'm misunderstanding you. We have 6 instances of amendment on this.
right,
Right.
under
so
2.1.
in
And
2
those
point-
were the ones we went through last week. So
All
the-
6 of them.
Yes, so
Okay,
the only change was that highlighted language that was for consistency, to say for themselves or for a family
Right.
member.
Okay, so I think we signed off on most of these, and the ones we're considering additionally today are the ones that were raised by Megan last week.
Right. So do you want me to put those ones up?
Sure. That would be great. And also, even though Carrie didn't send it to each one of us individually, Carrie Brown's testimony, I would hope people had read as well. And I don't know if there was any other witness, we were supposed to get 2 others, and I'm not sure we got the other testimony. Because you have to go to our web, because Carrie didn't email it to all of us individually. You just posted it, so people have to know to go to our website to look it up. The other people whose testimony, yeah, we have that, but she brought that, yeah. Okay, great.
Okay. So
Okay.
draft 3.1, and I do have copies.
Okay, great.
This is the one from this morning that I worked on yesterday at the request of Senator Chittenden.
You got copies for everybody? Page 1 of 3, but this is only 1.
Yeah, the last
So
page.
this is 3.1, these are the,
These were the changes that were requested by the chamber.
okay, these are the chamber requests.
Could I speak to it, Madam Chair?
Sure, before Sophie goes through it? Sure, why don't you frame it up?
So I just saw that it was up for action this week, and I just heard the testimony from the chamber, and it seemed very reasonable. I support this bill, and if anything, this just, I think, makes it a little more durable. All it does is revise some of the language in there. So 3 things. One, on the locos parentis, I think it makes sense to just drop that language that says doesn't need, or this is what I requested. I'm not sure to speak for the language.
The first one is, you want to just go through the instances of amendment, so.
Well, okay, I just thought I'd speak to what I
Okay,
asked
great.
for, and then she can
Sure,
walk through the
which one
language.
is that? That's I'm trying to find it on this.
Third.
Third, okay.
So all it does is just strikes out the sentence that says no financial obligations are required. By eliminating that, it seems to then imply, more consistent with my understanding of what was presented on the federal obligations, that to be locus parentis, you need to have day-to-day obligations or have some financial obligation to it. So I just thought that no financial obligation just seemed a little abstract, and I didn't see a justification for it. So I thought that that would make the language a little more consistent from my understanding of the testimony that's come so far. The other thing that the chamber raised was the bereavement. I'm all for allowing bereavement unpaid. I just thought 2 weeks for a company of 10 employees. I agreed with what the chamber presented, that to have to hold a position open for 2 weeks with such a small possible workforce can be crippling. So if there was, I proposed to lower it to 5 days, but I also in discussions have heard, well, what if we allowed for 2 weeks that are not necessarily taken consecutively? So if there's additional requirements because you're the executor of an estate, but 2 weeks of missing out, just holding a position when that's also when they might be looking for other work, that can be very difficult for a small company.
If it's taken consecutively, I don't disagree.
Yeah.
I just, having been the executor of an estate and appreciating how much time sometimes what one might include in bereavement, i.e. managing the death, all the business of a death in the family. It's a big time commitment, and sometimes it's consecutive, and mostly it's not consecutive. Mostly you have to take time for the funeral and or the memorial service, and then you may have to take a day in court, and you may have to do another day with whatever. But I think that it's 2 weeks. I would not disagree that I think 2 weeks is a substantial amount of time. But I would be also happy to look at an amendment that looked at 2 weeks, not consecutive 2 weeks, but those number of days, because we're talking about work days, 5 days, so not more than 10 work days, and not consecutively.
So I shot this
Yeah.
email because I wasn't ready to support the
Yeah.
bill as is, and I
Right.
just thought we should take a closer look at some of the language. The last one really has to do with just giving employers the option, not the requirement, that they can ask for some documentation. How I understand, we're making this very flexible language so that when somebody passes in your life, then you should be eligible for bereavement. I just can imagine, and on the side of those trying to organize a business, to, if you have concerns, to be able to ask for some verification or documentation. I wouldn't want to disable that. So it seems reasonable to allow employers to ask for some information, some documentation of what is qualifying for this unpaid leave. That was my intent. And now if you want to walk through the very technical language from Ledge Council, that was what I asked for.
I think your framing up is very helpful. Thank you. And I appreciate that. I think, so Sophie, why don't you walk through and then let's discuss.
Right, so on the screen highlighted are the new changes. So as Senator Chittenden said, this would delete that second sentence in the loco parentis definition,
Okay.
which talks
What
about,
section is?
it's in section 2. It is page 4. What may be easier, I don't know if it would be easier. I have it within the.
Oh, here it is. Yeah, got it. It's number 9 in local parentis. Got it. Yeah.
Yeah, I'm just thinking maybe it would be easier to do it this way. What I did was create a document that just had all the changes in it. So bear with me as I skim through it.
That's
I just thought that might make it easier. So it would be deleting this sentence. So the in loco parentis definition means a relationship in which an individual has day-to-day responsibilities to care for and support a child regardless of biological or legal ties. And then it would delete the sentence that says financial support is not a requirement for this relationship, recognizing caregiving roles beyond traditional definitions.
We just asked for, sorry.
Yeah, go.
I just recalled hearing that it'd be beneficial to somewhat tighten this language. I don't know if this tightens it, but I just would be worried about some interpretations of this by just eliminating the financial support. And I kind of like just the first sentence as is, that if you have day-to-day responsibilities for the child, regardless of biological or legal ties,
Yep.
those include financial support, great. And if they just include picking them up, tending to them all day, watching them on summer breaks, I just didn't like that sentence as a disqualifier of sorts. So I don't know if that addresses the chamber's concerns, but I too thought that there needs to be, I think financial support needs to be a consideration, not necessarily a hard requirement. So that's where I came.
No, I agree. I think it's the relationship and the amount of time they care, which is key. So after we go through them, we'll have the chamber weigh in and the unpaid leave coalition or anybody else who wants to weigh in on these. Yeah, okay, great.
And again, apologies while I whistle through this. I don't want anyone to feel sick.
Thank you, Tom. Okay.
Okay, so this change is adding in when an employee gives notice to an employer about the intent to take leave, they would provide information on the notice would include the date the leave is expected to commence, the estimated duration of the leave, and then adding in that if the leave is for a family member, documentation identifying the qualifying family relationship. So that would go to the concern that Senator Chittenden raised in terms of what the chamber had requested regarding making sure employers know. So I didn't, yeah.
So
My intent was for it to be an option for them to ask for it. So I don't know if this language is mandatory, but what I said is I just didn't want to disable them from an employee or asking for this documentation.
yeah, and Sophie, where is that in the full document? In the
That's
whole
it.
doc-
It's on this page that's up on the screen.
I know, but what
Page
page?
8, bottom of page 8.
Hot down. So I'm
Well,
trying to
of course, the page numbers may be different given
Well, it's
the
okay.
edits that are in here, but
Page 8 and what, it's
E1,
E1,
yes.
right, an employee shall give the,
So I don't know if that is as optional as my intention was. This is just the first time I'm seeing the language. But if if the leave is for a family member, the employer documentation may be requested.
I think maybe request, I think it's kind of awkward if it's your mother or father. I mean, I think it's your second cousin once removed. People might be a little, you might need a family email that says, and there may be circumstances where it's important that you show up. You never know. Family dynamics are challenging. But I think may is a good option. I'm not sure, documentation on some family, I mean, all you'd have maybe is an email or a text chain or a phone call to say, Aunt so-and-so has died, and it would be really great if you could join us at her memorial service. I mean, how do people feel? I mean, I think a may rather than a shall. Do we have a shall here? I can't.
Yeah, this just says the notice. So when they're just letting the employer know that they would advise them. So again, maybe it's just a question of taking out the documentation, but just saying, this is for my brother or whatever. I mean.
So this is in addition, after the end of the sentence, notice shall include the date the leave is expected to commence and the estimated duration of the leave, and then this is added, right?
Right. Page 8.
And leave is for a family member documentation. So this is still a shall. So I think the shall for the first sentence is fine. How do people feel about the second? And I would say, I would make this,
So maybe a sentence, just leave the current sentence
I
the
would
way
leave
it
the
is,
current
and then
sentence,
have an
which is-
added sentence, the employer may request
Yes.
documentation identifying.
I would think that would be fine. I mean, it's hard to, father, mother, I mean, some would seems a little silly, but I would agree that I think one might have an arched eyebrow and say, oh, really? How do people feel about this?
First, second cousin who died this year.
Yeah, right, okay.
Well, I mean, again, it's
Right.
how do you,
Right.
for someone who wanted to cheat,
They're gonna
this is of no help,
Okay.
frankly.
Well, but we're gonna assume most people aren't doing that, and so I think,
Yeah, most.
I think that the employer should be able to ask. So I think a May would be good. How do you feel, David?
I agree with Mays.
Good. May Day is tomorrow, so we want to be on board with May.
And then the third change was the one regarding the number of days that can be used for bereavement leave. So this was a switch from the current 2 weeks to 5 days, which was what the chamber had requested. And again, maybe there's language that could be 2 weeks, you know, but maybe up to 5 days consecutively, but 2 weeks in total or something like that.
Yeah, and I just think it's important. I would agree with Thomas. I think 2 weeks for bereavement consecutively is a lot for a small employer. I think that I just also appreciate how complicated some of this can be. And so is our understanding with bereavement leave that it includes what I had just brought up earlier, which is, you know, all the machinations of dealing with a death, all the business of dealing with a death?
Right, so bereavement leave is defined as,
Right, that's
definitions here, right, this is on page 1, but it includes leave taken in relation to the administration or settlement of the deceased family member's estate. I mean, maybe if it's 5 days, but up to 2 weeks if you're the executor, or I don't know, administrator
I
of the
wouldn't
estate.
qualify it too much because it can,
You never know.
there may be states where there is no executive, I mean, you know, where they die without a will, or, but, you know, which are even messier and require more time if you're an only child. I mean, just, you don't have to be too creative to think about the challenges involved. If for any of us who've dealt with the death of a parent or a sibling or a whatever, I think that it just key not to be consecutive. So I would I wouldn't make it too complicated. I would just make sure it's not consecutive 2 weeks. No more than 5 days consecutively, something like that.
Within a 30-day period over the
Yeah,
5 weeks.
Well,
5 days
but
consecutive over a 30-day period. 2
yeah,
weeks total with no more than 5 days consecutive over.
yeah, but I mean, you may have time. It may be 6 months. I mean, it may take a while to do some of this. I mean, if this is over a year, right? All these unpaid leave opportunities are over a year. What?
And what do you mean by consecutive? For example, if the person took off from Thursday and you went for the weekend, it's not actually.
Well, work days.
Sorry.
We're talking about work days here, right? Isn't that an understanding that the bill is?
Yeah, but it wouldn't hurt to clarify. You could say up to 5
Okay.
work days consecutively.
Yeah, okay, let's do that. And then I think over the course of a year, it's not unreasonable to think that there might be 5 additional days, maybe 1 every 2 months or something, where you have to deal with something substantial. I don't think most people will do that, but we all know some pretty challenging life settlements that require some time away from work, which is, because nothing's open on the weekend when you're trying. Courts are not open on the weekend, and financial institutions are not open on the weekend, and your lawyer's offices, if you are lucky enough to have one, isn't open on the weekend. So sometimes it just does take time, unfortunately. Would people be okay with that?
I think just some refinement of the language, yes, so that sounds good to me. Non-consecutive, I was just looking at what the other states did, and
Yes,
A lot of
so Sophie, yeah, let's look at that. Thank you for providing us.
so a lot of them have it within 3 months of the death, or taken within 60 days of the death.
Oh, I see where you're coming from with that, yeah.
So
Illinois is 6, yeah.
California is 5 days. I was just imagining a small business that if you have an
Yeah.
employee that takes 2 weeks of unpaid and they have to hold that position for 2 weeks, it's just really challenging. So I'm fine with the 2 weeks spread over a period of time to address just those types of concerns, but.
Would you be willing to then, do 3 months, of death? I mean, anyway, I do know some of these things take a while, having witnessed it.
Yeah.
Because I do 5 days, and then, the opportunity within 3 months, but I don't actually think you probably need to clarify it, but anyway, what are people thinking? You know, so you're interested in sort of limiting the other 5 days to 3 months, or to 2 or 3 months?
Yeah, I'm fine with 2 weeks of day, but I could go in any direction. My concern is the 2 weeks consecutive
I agree.
right after a death.
I agree.
because I could see, yeah.
I
So-
am in agreement.
If 2 weeks taken over 90 days or the year, I'm fine with that too, with no more than 5 consecutive in a 30-day period or
Oh, I see, 5 consecutive
or no more than 5 consecutive, I guess.
I
but
would
then
just
they'd
say
have-
no more than 5 consecutive, because that's gonna probably be, and then the rest not in the year, because you never, I mean.
And it's up to 2 weeks out of the 12 weeks.
Yes,
I mean, you can't.
exactly, with no more than 5 days taken consecutively.
We're about to hear from some really smart people on this, and maybe they
Yeah.
have some ideas too.
Exactly. Anybody want to weigh in on this? I mean, this is a conversation. We're trying to make up our minds. So speak now or forever hold your peace. Yes, Charlie.
Hi there, I'm Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. On the bereavement piece, we represent survivors and victims of violence. And so the scenarios that are coming to mind for me are the several times a year when domestic violence fatalities happen in Vermont. And the amount of time that it takes, both immediately after that scenario, as well as in the following months and years, to address the logistics of those situations and heal from that very serious trauma. And so I would urge the committee to consider situations like that and the flexibility that surviving family members need to address the range of horrible situations that happen when a loved one is killed.
Have we not addressed that slightly separately with domestic violence? I think we have.
We have the safe leave provisions that are in.
Yeah, so I think with the safe leave provisions, we're taking care of that. I think of, and if we have to further define, I mean, I think bereavement involves, and I appreciate that a bereavement may be the death of a family member, but that coupled with safe leave, I think would more than, I mean, I think the safe leave covers a family member who has had somebody, a family member die in a domestic violence situation, don't we? Sophie?
Yeah, I think if you have to react to a situation, the safe leave would.
I think safe leave is the harbor for this. It covers it.
It's my understanding that if a surviving family member needs to go to court in a murder trial, that would be covered by court leave. But I cannot think of a place in the safe leave definition where that would be covered right now. Care for surviving people who have experienced abuse, I believe is definitely covered by safe leave. But I don't believe that responding to fatalities is covered by safe leave.
Then I would encourage us to do that.
To broaden the safe leave to include.
I would
fatalities.
encourage our looking at safe leave rather than expanding bereavement, because I think that is actually probably a smarter place for us to expand. And I had assumed safe leave covered that. Why don't we just look at page 5, which is the safe leave, number 12. Why don't we look at the safe leave definition? Because it means the leave of absence from employment by an employer because the employee or the employee's family member is a victim or alleged victim of domestic violence, sexual assault, death, or stalking. I would think if we included it in one of those two, that we would, you're right, it doesn't say that. But I think that would be a good place for us to expand it.
So
Any other thoughts around the room? I think that's the place for, oh,
Hello.
hello, Miss Emily.
Hi. Do I need to state my name?
Yeah, you do.
Okay. For the record, Rep. Emily Krasnow. I strongly believe in compromise, and I believe that including these provisions is still a very strong step forward. Again, I not only have lived experience as someone who's buried both my parents, one at 13 and one at 2 years ago. Watching my mom take that time and leave her job to after the grief of my dad, and then myself having to figure that out 2 years ago. I do understand, and I'm grateful that that's still part of the bill, very important. And so I do support the changes, and I appreciate the committee's time getting to a place that can be more palatable.
Thank you.
Thank you.
Thanks. Any thoughts on the safe leave expansion?
No, I think that's a good area. That seems like a piece that could be, as Charlie mentioned, an additional piece there to cover those folks. Again, the three important umbrella issues in this bill, and the intent are the safe leave, bereavement, and also including people equitably. We've just reflected on 25 years of civil unions, which I was around for, and we're still looking at bills now as policymakers that exclude people based on who they love or who they are. So that's a huge component. So all of those are still intact in the bill, and I think that's important.
Great, thank you. And thank you, Charlie, for identifying that one. Anybody else? Megan, you want to weigh in?
I appreciate the committee taking our thoughts on this into consideration, and that the idea of balancing where our employers are at right now with their struggle on having so many open jobs and what it takes then to keep jobs open longer. And I think that's part of why it's especially important. And I think this committee already had general practice last year about the importance of the unemployment funding available for victims of domestic violence, so that as much time is needed that those folks are financially supported when an employer just is not able to provide job connection. But I think unless I'm wrong, the example that was given last week about an employee taking time off to support their daughter, it didn't sound like that employee was fired for taking that time off, that their employer supported them for that. And I think employers are generally supportive of that, but that question of it, this is your brother-in-law that died this year, can I get some evidence to that, or can I see some documentation, or can you provide me a self-attestation? The self-attestation is listed as a acceptable document under safe leave. So I think an employer being able to ask that question,
I think it's important.
We won't see a lot of folks necessarily doing that, but there may be
right. And what we're all forgetting is, of course, some of it involves travel. So if it's out of state, the travel time that's why the 5 consecutive days is ample, I think, for that. And then you have the other time in case you're actually more immediately involved with court or lawyers or whatever else has to be involved. Any other thoughts weighing in on? Did we finish going through them, Sophie? You want to?
Yes, those were the 3 proposed changes.
Anybody else want to weigh in? Unpaid family leave, you want a coalition, you want to weigh in?
I can speak briefly about the look of practice and the documentation requirements that works. So
just identify yourself.
Yeah, for the record, my name is Emmett Avery. I manage the Vermont Paid Leave Coalition. So just very briefly, I think this information is already in your inboxes, but in look of parentis relationships, including those in Vermont law, would bring us in line with the federal FMLA statute. Which is the standard that's currently referenced in unpaid sick time. So I'd encourage the committee to be just cognizant of that as they adjust local parentheses definition, just to make sure that it's still in line with the federal one, so it doesn't line up.
So Emmett, just on that point, I think to go to Tom's question, does eliminating that last sentence, is that critically important? Because I think to me, the first sentence is the key piece.
I'm not aware. My initial read is that I don't think eliminating that end sentence would change it.
I don't.
But I would just encourage to reference the Department of Labor's definition. There's a pretty good fact sheet that I sent around.
That's the U.S. Department of Labor, right? So you have the fact sheet, so pull it up and see, because we aren't necessarily all on our,
I'm looking for it now.
Website?
Yes, Sophie, what's your thought?
No, I haven't seen it, so I don't know.
I could send this to you afterwards, but that'll be helpful.
Okay. Great, I think, Sophie, what's your take on if we ended that sentence, if it would, because what's your thought about if
I don't think that sentence is gonna change, the
That's not my
application
gut either.
under FMLA
Right.
or under the PFLA.
Right, anybody else want to weigh in? We've got your pilots? You can fly safely now, they're rested, happy.
Was that the to-go legislation?
To go with pilots, that's just what we need. Airplane pilots with to-go containers on the cockpit, like, oh my God. Jeez. So what would you suggest about expanding safe leave before we send you off to it with a new draft?
I
And see
would
if we could
double-
do a new draft.
Yeah. I can do that quickly. I would double check with Charlie to make sure that it's in the right place. I mean, I think domestic violence, I think it would cover,
Death,
someone
would
who's
it cover
killed
death?
as a
We've got
result
some
of
good-
domestic violence, but I'm happy to.
10 minutes.
We're landing,
Yay.
we are channeling the pilots, we are landing unpaid leave here.
Yeah, so I would just double check with Charlie on that. And then the other two changes were the one sentence around the employer may require documentation identifying
Right.
the family member. And then, the bereavement leave, that it can be up to 5 workdays consecutively, but up to 2 weeks of the
Over the course of the year.
year.
Okay,
Right.
right, just to deal with court lawyers, they're just things that take you a day at a time that
Right.
may not be.
But
Great,
those changes I should be able to
great,
get back to you this
okay.
morning, if that works.
Yeah, it would be great, and if you and Charlie,
I'm so sorry. I just have one quick question about the documentation piece.
yeah,
I'm not sure if that applies to the safe leave language in a domestic relationship, like documentation verification within safe leave. If it is just a self-attestation, as is like currently required for safe leave, I think that is appropriate. Requiring documentation beyond that could be potentially dangerous for survivors of violence. And so that's just one piece that I wanted to ask a clarifying question about.
So I want to make sure it's narrowed to just bereavement requests, not the other one.
well, why don't we narrow it within safe leave? Again, I would incorporate the self-attestation in safe leave, just as we might incorporate death in safe, so that we're not encumbering bereavement, I think.
So the location right now of the language about an employer may ask, again, once the change is made, an employer may ask the documentation identifying the family member. That would just be across the board. That would be for all
Yes,
types of.
okay, is that,
In the under safe leave documentation, it specifically notes that a
Then
self-attestation
that's
qualifies as documentation.
fine.
And so if that is the case for all forms of leave, I think that would be entirely appropriate.
Right, you mean in other words, if someone's having a bereavement leave or something? Well, there are specific documentation requirements for bereavement leave, like an obituary or whatever. It was more just to do with, I think from the chamber's perspective, just wanting to make sure that they knew what the actual relationship was between the person that passed away or whatever the family member that's sick, that what is the actual relationship between the two. So I think that's, as I understand it, that's all that's being asked here is just what is the actual family relationship, not beyond that.
Right. And as long as self-attestation is in safe leave, I think we're fine.
Okay, perfect. Thank you so much.
So, Sophie, I would say if you and Charlie could coordinate on the, including death and the death in safe leave, if that needs expansion or what is assumed versus what's explicit.
Yes.
Let's see if we could, if it's possible to do a new draft before, we're gonna take a break to like 10:20 right now and unless there's further discussion on this, I think that we're in a good place. And if we could do that, and then we could maybe vote it out at 10:20 if that was possible.
Okay, we'll see what I can do.
Yeah, and Charlie, would you trail her?
Yes.
Okay,
I'd
great,
be happy to.
good. Nice work. Great, I think we're gonna take a break and come back at 10:20 and try and vote this out.
I guess
Hi.
I'll hold it open for me.
Hi, we did good.
Good.
So,
Can you hold it open for me after?
oh, yeah.
Okay, okay, I should
I
be
wanted
back.
to ask you about what you've
Thanks,
been doing.
Allison.
Oh, okay.
Emily, thank you. Oh my God, it is like suffragette day here.
Thank you.
As you turn around, sorry.
Oh, good.
You've got the strings on the back.
Thank you. You're welcome. The tag on the back. There it goes. Thank you.
Well. You should.
Same way.